I'm going to start the third section of this webinar regarding unfair competition and trademark issues. So I'm going to share my screen now. Well, let's talk about how actually unfair competition and IP rights relate. And in that sense, the Andean legislation has already regulated unfair competition discipline. So actually, within the trademark, let's say, legislation, we have the chance, if you are a trademark owner, and if you don't find relief within the trademark legislation, you can go as a complement-based, as a complement discipline to the unfair competition statute. So in that sense, actually our Andean Community legislation says that unfair competition acts relating to industrial property may include the following. And it's important to know that are other types of unfair competition acts. So this is just some examples of some unfair competition acts that actually we can, let's say, analyze here within the Andean legislation. Of course, there is confusion acts, false statements capable of discrediting a competitor's commercial activity, or a statement that may mislead the public. And of course, these unfair competition acts can be also materialized with advertising activities as well. But for this presentation, I'm going to focus on confusion. And in that sense, before that, I would like to speak about the right to imitate, as you can see on the screen right now. So it is something interesting because actually the court, the Andean Community Court, has issued this prejudicial interpretation judgment regarding the right to imitate. So this means that actually imitation as part of a business initiative is actually permissible. So if you find in the market, let's say that there is a competitor that actually is part of your benchmark, and you see that competitor has, let's say, some attributes that you would like to replicate or to imitate, that is possible. And of course, that is part of the freedom to economic initiative. So in that sense, you can do it as long as it doesn't collide with IP rights, or as long as your offer within the market is really differentiated. So of course, it doesn't generate a likelihood of confusion in the consumer. So it is important to understand that the whole framework of IP rights here in the Andean legislation, you have to actually analyze it within a broader framework, which is the competition. So actually, trademarks are tools for businesses to compete, and you have to, in that sense, respect some rules for a fair competition in the market. So I'm going to talk to you about a recent case that actually appeared here in Peru regarding actually a business that you can see on the screen. Basically, this type of case is what is known as trade dress. So Maria and Menara, the picture that you can see here, they do a lot of pastry. They're in the pastry business, and they found out that Mafer Lucia, which is the other competitor, actually started business in the same category as well, and they started to copy a lot of elements of Maria Almenara's business activity. For instance, you can see that the packaging is quite the same. Also, if you would go to the store, you would see that people that actually work there wear the same, let's say, suit. You can see that it's the same color, it's the same style, and even it has the same logo, or quite the same logo. So Maria Almenara is an M and an A, and Mafra Lucia is an M and an L divided by say like this line. So it's like you can see, and you don't need to do a lot of effort. You can see that they're really quite similar. And here as well, you can see the MA and the ML. So actually, of course, it's important to know that when you're filing an infringement action based on a trade dress grounds, actually you're not expecting to have rights over certain elements, for example, colors or other designs, but actually it's about the overall perception that a consumer may have regarding the business. So that's actually what constitutes an infringement regarding trade dress. So here you can actually see this is an extract of the decision of the Fair Competition Commission of the competition agency here in Peru, that you can see, of course, that that trademark is involved, but you're not actually per se enforcing the trademark. Let's say that the registered specimen with the trademark authority, but rather you're actually protecting other elements that constitute, let's say, like the brand identity of your business. So it's regarding the overall perception, again, of the combination of all these elements that may evoke in the consumer a specific economic operator. So that's the main idea regarding how you actually protect trade dress in Peru. And also, of course, we have other interesting case that actually happened in Colombia. So you can see now on the screen that, of course, everybody knows Big Peru, rap. And then actually you would find in the market Alif Wrap. So at first instance, you would say, hey, these packagings or these products are quite similar. So actually Procter & Gamble brought this claim for unfair competition based on this trade dress. But actually the Colombian authority, which belongs to the Superintendents of Industry and Commerce, said that the overall impression, of course, it is similar, but not to the point that it may generate risk of confusion. So if you can see both examples regarding the Peruvian case and the Colombian case, and if we see in a more detailed way, you can see that in the Peruvian case, once you see both economic activities, you would feel that the overall perception, based on an overall perception, you may be confused of actually, if you go to the store, you would say, ask yourself, am I buying a product of Maria Almenara or Martha Lucia? Maybe you would be confused regarding the origin of the business. But for in this case, I also feel that are similar, but not quite similar to the point that may generate risk of confusion. Of course, other elements that are part of the analysis when you're within these types of procedure is to actually analyze if such colors or the way your competitor or you may be using perhaps the packaging is actually a normal or a current usual use within the industry. So in this case, perhaps, I mean, the authority in Colombia actually also may have analyzed these other aspects that are perhaps common for this type of products. So again, it's not about the isolated elements on how you present your business, the trade dress, but how actually the overall impression may cause in the consumer. And based on that, you can, of course, initiate an infringement procedure regarding this unfair act. So this is what I wanted to focus for unfair competition and trademark issues. I think that actually are really two, let's say, well-known examples, or really good examples to see how actually the unfair competition is related to IP rights. Again, you are not enforcing per se the trademark, the M&A, Maria Elena versus Mafer Lucia, perhaps on a phonetic grounds, but you're actually trying to enforce the overall impression of your business, which is related to an IP right per se. And another takeaway from this section regarding the Andean legislation is that it is okay to imitate. Actually, the system promotes imitation, but of course it has some limits. One limit, again, is that it doesn't have to collide with IP rights, and the other limit is that you have the duty to differentiate your offer regarding other competitors. So thank you for watching this third part of the presentation. I'm gonna hand over the floor to Rick to start the fourth section.